Our second case this morning is another motion for discretionary review. Case number 61046-9, Department of Transportation v. Flatiron.
And good morning again. So counsel for petitioner, you've got 8 minutes for this portion and you're reserving 2 minutes for rebuttal. You can proceed when you're ready.
Thank you, Your Honor. Gregory Martin again for FLJV in its action against the Washington State Department of Transportation. So this is the second of soon-to-be three motions. We're not saying that the third motion is at issue here. No, it will not moot what is happening here. It is a continuation of the issue that we see permeating this case. This court, this trial court, does not properly apply the state standards for motions for summary judgment. She is making errors in determining material issues of fact. As I noted before, the Haley case, the trial court may not weigh the evidence, assess credibility, consider the likelihood that the evidence will prove true, or otherwise resolve issues of material fact. That is exactly what the trial court is doing. She's taking a very large, complex, multifaceted dispute. She is accepting.
So, counsel, you said she quite a few times now in this argument and the previous one. This court's practice is generally referring to the Supreme Court as just to refer to it as it.
Yeah, I apologize, Your Honor.
It's okay.
Oh, noted, no. Change my ways.
Thanks.
As I said in the prior motion, we respectfully request the court take this appeal to address an issue that is now permeating the case. That, as I mentioned before, we are 2 years from a trial date with extensive pretrial discovery. That once we go through a trial, this goes up on appeal. Large portions of that pretrial discovery are going to have to be redone because there's going to be debates and arguments about what is relevant or what's not relevant, what's in the case, what's not in the case. And even though it's a very large, complex case, again, the issues before this court are straightforward and relatively simple. Is the court applying the correct standard in summary judgment practice?
So with respect to this COVID motion related to the COVID claim, how do you meet the effects prong requirements of 2.3B1 and 2?
So with B1, because the error is obvious, the trial itself is useless. We're going to end up redoing this trial years down the road after redoing and taking the time of a second jury to sit through a more than month-long trial a second time. As it relates to B2, this is really an issue for the court itself because this issue not just permeates this case, if this is the view of the trial court as to what the summary judgment standard is, this is going to affect other participants, other parties, other litigants.
With respect to B1, the effects prong of B1, you say it'll make the trial useless, but is that speculation? Because in theory, you could win on your remaining claims that are going to go forward on trial and be made whole based on the remedy from those claims. So there may not be a need to appeal at all.
Yeah, respectfully, Your Honor, that's an assumption that the COVID as a differing site condition, type 2, is duplicative with other claims in the case. It is not. It is a standalone claim. There are dollars and time associated with that specific claim that if that does not go forward, those aren't recouped in other claims that are pending. These claims do not overlap. They're separate and distinct. There are dollars associated with that particular claim, largely inflationary pressures resulting from COVID that are not collectible under these other claims. So if we do go through a trial, the trial will not focus on those large amounts of money. It will deal with other things, and we will still have an appeal because it is a large amount of money that we contend we're entitled to under the terms of the contract.
And I may not have a full grasp of the substantive nature of the claim, but from what I've read so far, it seems like your claim is that COVID is a site condition issue because it's physical in nature, because it has virus
Correct,
properties related to it, is that right?
correct.
Is there any case holding that something like pneumonia or some other bacteria or flu virus meets that definition?
There was a case out of when the Spanish flu came up, and it's escaping my recollection right now, but it has been some time. I'm not saying that it's not unique, but these are all questions of fact. Whether COVID is physical of nature, whether it is unusual or unknown.
So if it's unique, admittedly, how can it be obvious or probable error to cite on one side of that uniqueness or the other?
Well, I think we're mixing and matching things, because the standard, if you look at what constitutes a differing site condition, the trial court did not say it's not a differing site condition. The trial court said we didn't provide notice of that differing site condition. Those are two different things. If we were on a motion relative to it being a differing site condition, we would present evidence how it is physical in nature, how it is unique, how it is unusual. And that is why it is a differing site condition under the definition of the contract. You don't have a differing site condition for something that's normal to be expected. So that's why it is a differing site condition. As it relates to the notice element of it, the court decided we needed to use the term differing site condition. And that's not the contract. The contract does not say that anywhere, that we have to use those words. We have things we have to demonstrate for our notice. We have to say, what are the conditions expected? What are the conditions encountered? What is the significance of the difference between the two? And as the court noted, the trial court noted, there is a raft of correspondence going through all of that. And the singular reason that the trial court granted WSDOT's motion for summary judgment is we did not use the term differing site condition. But the headings in the contract, based on the terms of the contract, do not control. They're not to be used. They're for ease of reference only. When you look at the words under that clause, it says we have to identify the differing site condition, which is COVID. We have to identify that, which we did. But it doesn't say we have to use the terms differing site condition when we're identifying the differing site condition. That's not required. And WSDOT easily could have included a form or different language or a format that they wanted. When you hit a differing site condition, have in big bold letters, differing site condition, and run through what it is. None of that's required in the contract. So what the court did was accept WSDOT's interpretation, effectively taking extrinsic evidence as to the meaning of the contract based on WSDOT's argument that the term differing site condition has to be used because how would WSDOT know otherwise, whether it's a differing site condition or not? But none of that's required. None of that's required in the contract. And if we want to talk about strict compliance, right, WSDOT likes to go to this idea, we have to strictly comply. What do we have to strictly comply with? We have to strictly comply with what is written in the contract. And the term, use the term differing site condition, is not written in the contract.
And so the purpose of notice is to put everyone on notice as to what the claim is being made. Your argument is that by referring to COVID, you've put them on notice as to the fact that you're making a differing site condition claim, even though no one's applied it since allegedly the Spanish flu?
Your Honor, I'm going to take my 2 minutes if I can and waive my rebuttal to answer this point, because this was the point I wanted to make to the court when the court denied my reply on this point. The function of notice for a differing site condition is for the owner to make a different determination, is to decide what to do, not to evaluate claims. It's in real time, decide how we are going to handle this issue. You come across a boulder, okay, and the contractor says, hey, I got a boulder in the way. You didn't tell me there was going to be a boulder in the way. What do you want to do? Now, do I have to say, oh, by the way, it's a differing site condition too, for them to then react? No, WSDOT now knows there's a boulder in the way. What do you want to do? You want to pay me to remove it, or do you want to come in and get it out of the way? That's the function of notice. And that's why it's written the way that it is in the contract, so that WSDOT can make a decision. What do you want to do? And they did. They did make decisions. They suspended the work for a period of time. They wouldn't allow co-location. They required additional personal protection. They made decisions along the way as to what they wanted to do based on the very notice that we provided them. Even though we didn't use differing site condition, they made determinations. They decided how to spend their money. They decided how we were supposed to react. That's the function of notice. That's why notice was given. So in this situation, what the trial court has decided is because we didn't use this word, differing site condition, WSDOT was in a fog. They didn't know what they were doing. They had no ability to make any kind of decisions or choices, notwithstanding the fact that they suspended the work, they directed us to have PPE, they wouldn't allow us to co-locate, any number of decisions they made along the way because, yep, we put them on notice.
All right, thank you, counsel.
All right, thank you.
And counsel for respondent will reset the clock, and you can proceed when you're ready.
Good morning, Your Honor. May it please the court, Rachel Groshong on behalf of WSDOT. I'm going to focus on RAP 2.3B1 because I don't really think there's an argument here that anything outside of the proceedings is affected. So FLJV needs to show obvious error, and the court here did not commit any error, let alone obvious error. I want to address those notice points that were just raised, but I think it's helpful to set the context here that the trial court was evaluating this motion for summary judgment under very clear Washington case law about strict compliance. This court, Division I, and the Washington Supreme Court have all found that WSDOT's provisions in this very contract need to be strictly complied. These are the notice, protest, and dispute procedures that have all been upheld, and all of which have routinely been upheld on summary judgment. So we cited 3 of these cases in our briefing to this court. Most recently, the CA Carey Corporation versus City of Snoqualmie case. In that case, Division I affirmed the trial court's grant of summary judgment to the city after the contractor failed to strictly comply with the protest procedures of 1-04.5 of WSDOT's standard specs. Same provisions here. The Carey court also reaffirmed that strict compliance rather than substantial compliance is what is required.
So does strict compliance require using specific verbiage referring to a differing site condition specifically, or can you just say, hey, there's a boulder here?
Strict compliance requires putting WSDOT on notice of a differing site condition. Whether they use differing site condition, DSC, reference 1-04.7, which is the contract provision at issue, saying that there is a physical condition at the site of an unusual nature, it's a type 2 DSC. They didn't do any of that. So it is a far cry from strict compliance. It's not compliance at all. WSDOT was not on notice that COVID was a differing site condition. And if the court digs into the record, FLJV relies on this general notice that it's March 16, 2020 at Appendix 212, where it says, COVID is this new thing that's happening and it's really affecting us and we don't know how it's going to affect us. And WSDOT responds immediately and says, please promptly submit any requests for impacts related to the COVID-19 event per the terms of the contract. So then we go down this path of the suspension for convenience and direct health and safety costs. All of that was protested. WSDOT made a determination. They disputed it. It resulted in 2 change orders, which FLJV agreed to and did not protest. And that's the end of the matter. There were 2 carve-outs from those change orders, which are not at issue before the trial court and not at issue today, COVID time and health and safety costs after May 31st of 2021. That's it. Everything else related to COVID is waived. It was not protested. It was not put, and WSDOT was certainly not put on notice of a differing site condition. And the trial court got it exactly right when she found that there was nothing magical about using the terms of the contract. She also did not rely on the headings as counsel is arguing. The term differing site condition is used throughout 1-04.7. The actual terms of the provision say that FLJV shall promptly notify WSDOT, quote, in writing of the specific differing site conditions. It goes on to say that FLJV has to include the conditions represented in the contract documents, the conditions encountered at the site, and an explanation of the difference. None of that was done here. And a general reference that COVID is this new thing and we don't know how it's going to affect us without any reference to the contract or any mention of a different site condition or a physical condition of an unusual nature, as a matter of law, that is not sufficient notice. And it's definitely not strict compliance under very well-established Washington law. And going back to the strict compliance standard, we cite two other cases, Nova and Mike M. Johnson, which I'm sure the court is familiar with. There's many others, and all of these are decided on summary judgment. The courts routinely, all of the appellate courts in this state, routinely uphold grants of summary judgment for a contractor's failure to strictly comply with these notice, protest, and dispute procedures. And on this claim, the failure to comply was astounding. The first time that WashDOT got any notice of any type that FLJV was claiming that COVID was a differing site condition was in this litigation years after the fact. No one thought that COVID was a DSC at the time. It's not. But regardless, WashDOT was never put on notice. FLJV was paid over $13 million for COVID, for the suspension, for direct health and safety costs. Never mentioned COVID as a DSC during that time. And now years later thinks that it can bypass all of these provisions and make a claim. And the court was exactly right to say, no, you cannot do that. You failed to comply with the notice, protest, and dispute procedures, and you have waived. There was no error, let alone obvious error. Council made an argument about notice, and it's for the owner to decide in real time what to do. What do you want to do? And here, section 104.7 regarding different site conditions does say after WashDOT is given notice by FLJV of the different site condition, this prompts WashDOT to investigate the conditions at the site and make a determination about a different site condition. None of that happened here because no notice was ever given that FLJV believed COVID was a differing site condition. And 104.7 is very clear that no contract adjustment which results in a benefit to the design builder will be allowed unless the design builder has provided the required written notice. So again, the court was exactly right that none of that was done here under 104.7 or 104.5.
So counsel, most of your argument today on this motion is focused on whether or not the error was obvious. As to the effects prong, then, are you conceding that these claims would be completely different dollars and would require a retrial if theoretically there was an error?
I'm not conceding that. I think we don't know what the different dollars are. There's still discovery outstanding into that. But regardless, FLJV has a number of additional claims that are still proceeding to trial, including a number of differing site condition claims, breach of contract claims, breach of the duty of good faith and fair dealing. And FLJV has indicated numerous times that it plans to add additional claims as the project is ongoing to this lawsuit. So there is much still to do down below, and that will be tried to a jury, including also WashDOT's claims. WashDOT here is plaintiff and is seeking liquidated damages for the fact that FLJV is years behind in completing this project and has a declaratory relief action as well. And so all of that is still proceeding to trial, and this is just one of many claims that FLJV has, and a subset of dollars that it is claiming. And I don't know the amount of those dollars at this point in time. That discovery is still ongoing. But I don't think that FLJV can meet the effects prong because the trial certainly will not be useless. There is still a lot for us to do. And part of why, obviously, the obvious error and the effects prong can't be totally divorced from one another because these claims are routinely decided on summary judgment because it is a condition precedent to FLJV's ability to bring these claims in the litigation, and they completely failed to do so as a matter of law based on well-established case law. And so taking that together, I don't think that there's any basis here for discretionary review.
All right, thank you, counsel.
Just one more point that I want to make is that the trial court did not find any ambiguity here in the contract provisions. She did not find two different interpretations. She simply applied the very clear language, the notice requirements, and looked at what FLJV did and said in all of this correspondence, at no time did FLJV ever put WashDOT on notice that COVID was a different site condition.
All right, thank you,
Thank you.
counsel. I would just note to the parties that it sounds like this case is going to chase me into retirement. And so both attorneys for both sides referred to the court as a she, and it's just this court's preference to refer to the court as it, if possible, to avoid making it an overly personal attack or defense of that particular judge. So in future cases, if we could stick to that, the court would appreciate it. With that said, this matter will be taken under advisement, and thank you very much.
Thank you, Your Honor.
All rise.